You believe you have a clear-cut case of malpractice against your doctor. You believe the doctor was careless. You believe his carelessness was a clear-cut cause of your injury. Can you go ahead and get a directed verdict against the doctor before ever getting to trial? You want to know what this is about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, you can. There are some instances where everything is clear-cut. There are some cases where it is so obvious that the doctor was careless and violated the basic standards of medical care. And there are some instances where the injuries are so clear-cut that they were caused by your doctor's carelessness. In that instance, do you have to wait till you get all the way to trial for a jury to give you a verdict in your favor? The answer is no. There are some cases where you can go ahead and ask the judge, maybe it's in the beginning of your case, maybe it's in the middle of your case, for a directed verdict. Now, how does that work? So here's what happens. If you have the evidence in support showing that the doctor was careless and it's clear-cut, and showing that your injuries are a direct result of the doctor's carelessness, now you can go ahead and make a request to the judge. That's known as a motion. A motion is nothing more than asking the judge to take some sort of action. In these cases, in order for a judge to take action, such as a directed verdict, it has to be written down. And the reason why it has to be written formally to the judge is to give the defense an opportunity to reply to our papers. Now, it's easy enough to get in front of the judge during oral argument and say, hey, judge, we believe we're entitled to a verdict in our favor, without having to go through the entire litigation process, without having to go through discovery. And the judge turns to the defense attorney and says, what do you have to say about that? Judge, this is early on in the case. We have no discovery. We don't know what he's talking about. By presenting all of our proof in appropriate form, as if we were presenting proof at trial, now we can show to the judge that we are entitled to a verdict in our favor before ever getting to trial. The defense attorney will then have an opportunity to respond and reply to our papers. Now, he's not going to simply roll over and say, yeah, you know what, you're right. Go ahead and give us a verdict against us. No, they're not going to do that. They're going to fight us tooth and nail. They're going to argue, hey, we did nothing wrong. And even if we did something wrong, so did you, Mr. Patient. And if we did something wrong and so did the patient, guess what? Whatever we did or didn't do didn't really cause your injury. And they'll turn around and say as another defense, hey, if we did something wrong and you did something wrong and maybe we caused your injuries really are not as bad as you claim them to be. Those are the typical defenses that we see in these medical malpractice cases. Let me give you a great example. Let's say you go in to have hand surgery, and now the doctor tells you it'll be routine, you'll be out in a few hours, you can go home. Well, you come out of surgery and guess what? You've got a third-degree burn to the shoulder on the opposite side of your body. How did that happen? You were asleep during surgery. This never should have occurred, right? You had no control over what happened in the operating room. So now the only people who were responsible were the doctors and the hospital staff. And your injuries are significant. So you don't really need a medical expert to recognize that, hey, if you're operating on the hand, you shouldn't come out with a burn on the opposite shoulder. Just shouldn't happen. So in that instance, not only can we show to the judge that, listen, the only reason why you suffered this significant burn is if the people in that operating room were careless. And as a result of their carelessness, you now suffered this significant injury. In that instance, the judge would likely have no choice but to say, yes, you are entitled to a verdict in your favor as to who is responsible, legally responsible for your injury. But you know what? That's not the end of your case. You might think your case is over, but the reality is it's not. You only won part of your case. So now, since the jury at trial will no longer have to decide who actually caused your injury and who is legally responsible, the only other thing that the jury will have to decide is how much money you are to receive as full and fair compensation for all of the injuries that you experienced because of the doctor's carelessness, because of the hospital staff's carelessness. So there will be a trial on damages, and the jury will be required to give you money as a form of compensation. And you may have different elements of damages, including economic losses, time lost from work, as well as your wages, medical expenses, and you may have non-economic losses such as pain and suffering from the time of the incident up until the time of trial, and also into the future, known as future pain and suffering. So, to answer the question, Can you get a directed verdict if the facts support it? The answer is yes, you can. So why do I share this great information with you? I share it with you just to give you an inside look at what happens in these medical malpractice cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.